You're welcome back to Business Morning. Now, regulators in Nigeria's financial markets are sometimes accused of enroll duplication. According to experts, this has caused some form of disagreement between those in the same sector. Now, this is the focus of our conversation as we have been joined by a senior associate at George Etomi and Associates, Miss Adirike Adrim. Thank you so much for coming on the program.
Good morning. Thank you for having me.
I'm sure you've listened to a lot of issues regarding regulatory tussle in the country's financial markets. We'd just like you to give us a background to the history of any regulatory tussle that you know of.
Regulatory issues are not new. They've been in existence for a long time, even beyond the financial sector. In various sectors, we've had regulatory issues, especially where there are several regulators within a particular sector. Their functions can tend to overlap, and there can be confusion with regard to who is supposed to do what and who can sanction what. What we need to understand, though, is that in every sector, there is always a primary regulator. Now, that primary regulator is the major regulator within that sector. There might be other regulators who deal with other aspects, so it's not so much a duplicity. It's more like a situation whereby different aspects of a particular sector are handled by different regulators.
Okay. And I'm sure that you have instances, perhaps, of this tussle. We've had so many, some are actually ongoing.
Yes.
Sure. Just give us a background as to what has happened in the past and perhaps giving birth to what is going on at the moment.
Okay. Now, if we take a look at, let's take a look at, say, Lagos State, for example. We're aware that recently the PHCN was basically deregulated, was privatized. And the distribution companies have been sold to different, people, and their companies now handling each distribution company. We've had an instance where, massive land use charge bills were handed over to the distribution companies. Now, in this instance, the state government acts as a sort of regulator. So they're like a secondary regulator. And NERC is the primary regulator in the power sector. Now, what happened in that particular situation was that, apart from the fact that they were handed huge bills, massive bills, there was a threat of closing down the business. The businesses, if these bills were not paid within the period of time that they were given to pay the bills. Now, in this kind of a situation, it would destabilize the business. The power sector is very important. It's like the basis of, of any country, basically. NERC, which is the primary regulator, had to get involved. They interfaced, they were an intermediary basically in this situation, and they were able to resolve the issue. That's one instance. In another instance, the NCC, which is the primary regulator for the telecommunications industry, you're aware of that. There's also NESRIA, which basically deals with environmental standards. Now they recently, well, not so recently, in the last couple of years, handed down fines to a few telcos. One in particular that my firm got involved in. Now, what they did was that they handed fines because they felt that some of the masts, in placing them, they did not adhere to environmental standards. And we understand that the regulator's job is basically to create rules and regulations which would enhance the performance of their sector, but also at the same time to protect the consumer, which is us. Now, in this instance, NESRIA was trying to protect the consumer, the environment. And the particular telco took them to court. What they stated, their argument was that their regulator is the NCC, and that the NCC and the NESRIA should have approached NCC in that particular situation if they felt there was any, there were any issues. But NESRIA was actually doing its job. NCC cannot perform NESRIA's functions, and NESRIA cannot perform NCC's functions. So there have been, for a long time, there have been issues with regard to, where is the overlap? Where do we draw the line?
Isn't the law establishing these institutions, regulatory bodies, for instance, isn't it stated explicitly as to who does what? At what point would you be crossing the line? Perhaps, isn't that stated in the law? Because like you mentioned, in the telecom companies, you have not just one regulator, because depending on the areas that it's been looked into.
Precisely.
But shouldn't there be a law perhaps to demarcate and say, okay, this is who does what? If there's going to be an issue, this is who will handle it.
The law, the law that basically brings about these regulators states these things clearly. However, there will be overlaps. We can't avoid overlaps. What should be done when there are overlaps is that the regulators should engage themselves in conversation. There should be interactive forums, where they can discuss even before bringing it to public attention. They should be able to sort out their issues, amongst themselves. They do have some forums whereby, they meet and discuss. So they should be able to resolve all these issues and, come to the public with a united front.
Okay, I would like us to take a look at the conflict that's going on. I'm sure we've seen examples from this consumer price, the CPC and the Standard Organization of Nigeria, the FRC and the Central Bank, and sometimes the SEC and the NSC. Now, we've seen regulatory conflicts among these regulators, put it that way, in the financial market. And it's sometimes, there seems to be no resolution, no quick resolution of this conflict. Why do you think we have an extended battle, so to speak, among these regulators?
First and foremost, it is important that, amongst the regulators, there's nothing like, oh, I'm supreme to the other one. Like I said earlier on, there's always a primary regulator, and we're all aware of who they are. In the telecommunications industry, CNCC. In the, it's a CBN when it comes to, the banking sector. So we should always, with the power sector is NERC, we should always realize that all the regulators should be aware that there's, that one regulator which deals with the core business of that particular sector. However, there should be mechanisms put in place whereby they can, engage with each other, have discussions, basically resolve issues. Like we're aware that with regard to the NSC and SEC, in the past they've had their issues. In recent times, they've been able to resolve such issues, especially with regard to the dealing side, because they've had an interactive sort of relationship. They have more problems with the capital market side of it, which they're trying to resolve now by, executing an MOU. Parties are discussing. That's one way by which you can resolve issues. So with regard to, the FRC and the CBN in this instance, the FRC deals mainly with accounting standards. So they should, if they had issues, we feel that they should have approached, CBN to bring CBN into the picture and then discuss with CBN. And then CBN would, they would set up an inquiry, invite whatever corporation was involved, in this case, Stanbic IBTC, and discuss with them so that they would be able to come back to them with reasons for whatever whatever allegations were put before them. They would then have as a united front. CBN would then, state if any sanctions were to be, pronounced on them, to say, they would state that these are the sanctions for doing this and this and this, and now it's a situation whereby the public has been brought into their business and everybody can see that there's some sort of conflict. CBN has stated that, FRC did not follow the proper procedure when they were undertaking, this particular, when they went into, this action. So we feel that there should be mechanisms, like I said earlier on, put in place whereby, all the regulators can meet, they can come to conclusion, which, sort of like both, which has the input of all parties involved, and then they can, as a united front, present that to the public, or they can face the companies together. That the thing is that they're not against the companies. The regulators are not against the company. They're there to enhance growth in the business sector. That's what they're there for. And they're there to put standards in place so that these investors, this foreign direct investment we're looking for, will be able to come into Nigeria. There will be no fears that the proper procedures are not in place to protect the foreign investors.
All right, I'd like you to hold the thoughts for a minute. So we're going to break, and when we come back, we'll continue this conversation. We've been talking to Ms. Aderike Aderemi, a senior associate with George Etomi and Partners, and we've been discussing regulatory conflicts relating to public and private enforcement in the economy. We'll be right back.